May it please the court, my name is Joel Reeves, and I'm one of the attorneys for the appellants in this matter, the Driftwood Estates Property Owners Association and its advisory committee. I'd like to reserve 3 minutes for rebuttal.
3 minutes?
Yes, sir.
All right, sir, you may proceed.
Thank you, Your Honor. Your Honor, this is a real property contract case concerning the interpretation of terms in certain deeds and restrictive covenants. However, this case is also about the intent of a developer, something that the trial court foreclosed by not allowing any fact finding, and dismissing this case on Rule 12. Here, the parties are the Driftwood Estates Homeowners Association and a property owner, Sweeney's. The ultimate question in this case is whether the Declaration of Covenants for Driftwood Estates applies in full force to the Sweeney's property. For ease of reference, I'm going to refer to the Declaration of Covenants that applies as the Declaration, and the Sweeney's property as the property. Your Honors, the central issue here is that the Declaration explicitly lists certain property that is deemed subject to the Declaration. However, the Sweeney's property is not explicitly listed in the Declaration as being subject to it. However, the Declaration does detail a method to add additional properties to the Declaration's purview. It explicitly says that additional properties can become subject to the Declaration by following a certain process that's listed in Article 2 of the Declaration. The process being that, number one, the developer must record an additional declaration that, number two, adopts and incorporates the Driftwood Declaration by specific reference. We have that here, Your Honors. Less than 1 year after executing that declaration, the developer transferred what would later become the property to another party via warranty deed that explicitly noted in the deed that the property was subject to the declaration. The declaration was specifically referenced in the document, and it was recorded by the developer. The process was followed.
What do the cases say about whether just using that subject to language is sufficient without something more? And there seems to be an indication that the more requires a more specific reference to the property that's being subject to.
Yes, Your Honor. I would submit that the cases that have been referenced in this case lacked one crucial fact that our case has. If you look at the deeds from the developer in the cases that were referenced in all of the briefing, there is no reference or good reference to the declaration that is transferred from the common grantor to the next property owner in those deeds. In Lutzak, which was referenced all over both briefing, you had a developer who, well, let me address your question, Your Honor, is what's the something more? The something more is a common grantor, Your Honor. We have the developer who transferred rights in the declaration, in the deed. That's the something more, is you have that common grantor.
Well, what about, there were certain restrictions within the declaration that were applicable to these future properties. This Article 14, I think, involving the common areas and whatnot. So what's to distinguish that from, since that was specifically referenced to the future property development, where the other is not?
I would direct Your Honor to look at several other sections that are in the declaration. For example, look at in Article 1, the definition for properties. It says that all such existing properties and additions thereto, as are subject to the declaration, become properties under the declaration. This extends then to what is a lot, what is a tract. It contemplates the addition of additional properties. Also look at the language for an advisory, what the advisory committee has over its purview. It makes no differentiation as to who it applies to. It doesn't say the advisory committee only has authority to regulate properties that are on the original plat. It does not say that the advisory committee does not have purview over future properties. I would submit that there's enough language in the declaration that applies to every single property, and that the carve-out for just future properties is insufficient to find that that's the only section it applies to.
Let me ask you, you say the declaration is specific enough to cover the future properties. Doesn't the declaration itself limit the declaration to certain properties and not the future development? And then it goes on to say that if you want to include the additional properties, you can record a supplemental declaration. Was there a recording of a supplemental declaration to include the future development? I mean, that's what we really need to know. Was there such a supplemental declaration?
Absolutely there was, Your Honor, and that's the deed from the developer to the hills, I believe.
The deed itself? Is
Yes,
that
sir.
what you're referring to?
Yes,
As
sir.
a supplemental declaration?
Yes, sir. And I believe if you look at the Lutzak case that both parties have referenced, it specifically says in there that it doesn't really matter what the form of the document is, just that there be something binding the two documents together. There must be something where there's a declaration made whereby the developer is intending for this piece of property to be bound by the declaration. That's what you have in the Hill deed, Your Honor, that's directly transferring the property from the developer to the next property owner.
So what you're telling me, you're saying the declaration is in the deed itself that transfer the property, where they say that the property is subject to the declaration? Is that what you're arguing?
Yes, Your Honor. And if you look at Article 2 of the declaration, it says specifically in there that the developer, there's two requirements, that the developer record a declaration that specifically references the Driftwood declaration. There's no definition of what a declaration should be, and I will point out, it does not say that you need an amendment to the Driftwood declaration. That's what the trial court below found, is that the Driftwood Association needed to amend their declaration to add additional properties. That's not what Article 2 says. It says that the developer must record a declaration with a small d, meaning that it is a common noun. It is not a proper noun. It is not referring to some document that has a specific name. The developer must record something with a declaration stating that certain additional property is being bound to the Driftwood declaration. And that subject to language in the deed, that's a declaration from the developer saying that he intends to bind.
Well, that's exactly what the court said, and was insufficient to bind additional properties, isn't it?
I would
Including such language in the deed was not effective to do what you're arguing.
I would push back a little bit on that, Your Honor. If you look at Lutzak, there's a fact that's distinguishable in Lutzak. The developer did not, when the developer transferred the subject property in Lutzak to the trust that was the next property owner, there was no reference in the deed from the developer to the trust that that property was being bound, that the developer intended to bind that property to the declaration. That is a fact that is prevalent in all of the cases cited by the opposition in this case, Your Honor. I think that's crucial. It references...
Did you cite that to the trial court?
Yes, Your Honor, we did.
And what was the trial court's response in regard to that reasoning?
The trial court stated, Your Honor, that essentially the association or the developer needed to record an amendment to the declaration, and that was the extent of the trial court's finding. The trial court held that, in fact, it was subject to, the property was subject to the declaration, but that it was only subject to the future development portion of it. I would submit that that's something that the trial court missed, Your Honor, is that specific issue about needing that common grantor and what that language in the deed actually means as far as binding.
In other words, trial court required additional action or said additional action was necessary.
That's correct. I believe that the trial court held that an amendment or something to that effect to the declaration, the trial court wanted a document named the declaration or something to that effect, an amended declaration, adding the property to the purview of the Driftwood declaration. And I would submit that that's error, that's not required in this case.
What does Hughes versus New Life Development say about that? Are you familiar with that case?
Yes, Your Honor. I would submit in all the cases, Your Honor, that the common thread that we need is the developer and the intent of the parties. And I believe Hughes had the same issue. You didn't have the developer transferring property and explicitly referencing the declaration in the deeds transferred from the developer. I believe it's the same issue, Your Honor. And that's something that I know for a fact that the Lutzak court explicitly discussed, is looking at the intent of the developer. And that's something that I think I pointed out in the beginning, that I think that's what was missed in this case. What was the developer's intent? I believe we need fact-finding, at least on that issue, as to what the developer intended to do with this property. And that was simply not developed by the trial court by virtue of granting the motion to dismiss.
Well, if the original declaration says that to add the additional lots, you're going to need a supplemental declaration. And if in this case there was no supplemental declaration, and you're saying that you can do it by deed and make the property subject, that's exactly what Hughes and the other case says that you can't do, that you've got to file your supplemental declaration. There's got to be a recording of the declaration, not a recording of the deed itself, as I read those cases.
What is needed, Your Honor, is a declaration that the property is being bound to the deed, or rather to the declaration. You do not need an amendment which has a whole process. If it required an amendment to the declaration, it would say so, and that is not what is required. And I would submit that the developer did what was required to bind the subject property to the declaration in this case.
I want to ask you one question. I know your time's up, but I want to make sure I understand one thing you said. Are you saying that the distinction in this case versus Lutzak and Hughes and these other cases is that in those cases, in the chain of title, that the developer did not include the subject to language to the declarations in each of the deeds in which it transferred the property, where in this case it did? Is that the distinction?
I do think that's the distinction. I think it's huge. I think that's what is required. If you read Article 2, it says the developer must record a declaration. The developer must. And that's what happened in this case, Your Honor.
I understand your distinction about what kind of declaration. In other words, that it may not have to be, that it's a little d declaration, which can mean other things other than declaration, and that word is being confused with the big D declaration. So I understand your point on that, but I just want to make sure I understand this distinction that you're making between these cases, because I think Lutzak says you do it in the deed, but it's without more. This without more part is troubling to me, and I'm trying to understand if the without more you're referencing is the fact that you have a chain of title going from the developer subsequent to the initial deeds that were issued in this declaration, and that those chains of title include that subject to language, do not include the subject to language, rather, where in this case they do. In each of the deeds that went from from the developer to subsequent owners? Is that what you're saying?
I think that's the way you have to square LUTSAC with and the other cases that we've briefed today with the case that we have, Your Honor.
That those do not have that chain of title language?
That's correct. And I think that's how you square those cases, what's happening in this case, Your Honor, is that's the tie that binds all of those cases, is that there was not a transfer from the developer stating that the property being transferred was subject to the declaration. They all hold that. Thank you, Your Honors.
Thank you.
Good morning, Your Honors. My name is Richard Graves of the Knoxville Bar. I represent the appellees John and Kathy Sweeney. This is only my second time being the appellee, so I almost asked for time for rebuttal, but remember, I don't have to. Yeah, I think just generally, before we start out, this case, both procedurally and substantively, is on all fours with the Supreme Court's decision in Shea v. Sargent. That case was probably from the 70s. And that case involved, and I may butcher the word, it involved a demur. But that case involved the plaintiff alleging a cause of action against the defendant property owner, saying that the defendant is using property in violation of restrictive covenants applicable to that property. The defendant filed a demur, which is the equivalent of a motion to dismiss for failure to state a claim that we filed here, arguing the plaintiff's construction of this restrictive covenant is untenable and it doesn't restrict the activity they're complaining about. And the Tennessee Supreme Court affirmed the dismissal of that complaint. And when going through there, the Tennessee Supreme Court also set forth the applicable rules for regarding or interpreting restrictive covenants. Among those is that they must be strictly construed in the favor of the use of property. Also, that you look to the plain meaning of the words on the document. And unless activity is prohibited by the express and plain terms, it's not prohibited. Now, I think that's crucially important at the outset because, I think they started their argument with, we're here to determine the developer's intent, and I can take their argument going that we need extrinsic evidence to develop all of that. Well, the applicable rule is that intent is developed by looking at the four corners of the document. And I know there was a reference to the Hughes case earlier about how that may play into this. And I think the extrinsic evidence was referenced in the Hughes case to determine what the grantor intended to convey in that case. But that case was about whether the developer conveyed developer rights to a grantee through a warranty deed. And developer rights, while they affect real property to some extent, are personal property under Tennessee law. Restrictive covenants are real property. They're real property interests. They're subject to the statute of frauds. There has to be a writing about what their scope is. So this case procedurally is ripe for review at the Rule 12 stage because it is a question of law, and it's a question of law that the trial court correctly determined to be that the plain meaning of the four corners of the documents at issue do not allow the plaintiff to restrict our property in the manner that they're seeking to do.
Let me ask you a question. I'm interested in what your thoughts are with the appellant's argument about the distinction between these cases as to is that when the developer made transfers of the property, it didn't include the subject to language with reference to the restrictions, and that in this case it did. Is that a distinction?
I think I may, in fairness, be able to bifurcate their purported distinctions. I think there's two parts of it. One is that the transfer here was made by the developer, and the transfers in those cases were not necessarily made by the developer. The second distinction is they contended that the language in the deeds in the Lutsack and Massey case didn't specifically identify the restrictions at issue. They did. I'm going to read from the Lutsack case. Now there were two different transfers in the Lutsack case that the court that were discussed in the statement of facts. There was, I believe, a transfer of a deed to the defendant in that case that simply said, this conveyance is subject to all conditions of record without itemizing the restrictions at issue. but there were 3 warranty deeds in the chain of title, one of which I would think came from the developer, but as I sit here, I can't say that 100%. But there were 3 warranty deeds in the chain of title that did say that the conveyance was subject to the specifically referenced restrictions at issue. And the LUTSAC court had to grapple with the exact argument that the plaintiffs make now, that these 3 warranty deeds in the chain of title, by saying that the conveyance was made subject to these restrictions, applied the restrictions to that property. And I'll just read from the case. I'll skip over some parts, but otherwise it'll be direct quote. We are unpersuaded by defendant's argument that the 3 warranty deeds in the trust chain of title subject the trust property to the declaration. Interpretation of a deed is a question of law. The 3 warranty deeds specified that the conveyance was subject to the declaration of covenants, conditions, and restrictions and bylaws of record in, and then it references the books. Interpreting the deeds as defendants suggest would require us to disregard the clear provisions of the declaration and extend the restrictive covenants beyond their express terms. That's their exact argument. So there was language in the chain of title in the LUTSAC case that said this conveyance is subject to these specific restrictions, and this court held that that was not sufficient to subject those restrictions to that property. On the Massey v. Graft case, here is another quote from the case. I don't think it's a reference from the developer, but in the chain of title. The language in the warranty deed from the Dean estate to the University of Tennessee is as follows. This conveyance, however, is made subject to the restrictive covenants applicable to all of the lots located in the Deanbrook subdivisions of record in the specific reference conditions. So that's not a distinction. That's the exact issue here. And I would also want to note the declaration does encumber the Sweeney property because the Sweeney property is part of the future development. And the restrictions impose both a benefit and an obligation on the future development property. The benefit to access common areas, but also the obligation to contribute pro rata to their maintenance. So the trial court held in this case correctly in its ruling that the language in the deed that says this conveyance is subject to, in one sense, the property is subject to the restriction because the restriction does encumber the property, but that doesn't answer the ultimate question of what are the specific obligations that the restriction places on the property. And in that sense, the trial court just, I think, a straightforward application of the rule at issue in this case held that the fact that the conveyance is in the Hill deed from the developer and later in our own deed stated that the conveyance is subject to the restrictions here doesn't actually impose all of the provisions of the restrictions unless the restrictions by themselves apply to our property. So I think putting all that together, when this court has to interpret.
Let me ask you this: are you saying that? I think I asked your opposite the same question. Are you saying that article, those Article 14 restrictions, are what the deed was referring to? In other words, it's referring to specific restrictions that did apply to the property and not all of the restrictions?
That is the most this court can conclude from the face of those documents. And I think that also makes sense there's this case we cited from Arizona that talks about the reason why subject to language by itself doesn't impose reference restrictions on a piece of property beyond the express provisions of the restrictions, which is the subject to language is a limitation on the grantor's warranty of title, which is why it is beneficial for a grantor to make a conveyance subject to as many matters as possible to limit their warranty obligations. And so looking at the 4 corners of the Hill deed and looking at the 4 corners of the restriction, all that is a limitation on the grantor's warranty. Nothing more. And I think beyond, there are other provisions of the Hill deed that restrict the property, that restrict the future development at that time, including the limitation that it cannot be subdivided into more than 10 parcels. That is actually a restrictive covenant that the Hill deed created on its own. So the grantor of the Hill deed knew how to create restrictions that did not exist before that conveyance by way of that conveyance. And a common canon of interpretation is the expression of one thing is the exclusion of another. By expressly creating new restrictions applicable to the future development, the exclusion of any other new restrictions is apparent from the face of the Hill deed. I want to move on briefly into two other arguments raised by the plaintiffs, or claims brought by the plaintiffs in their complaint that likewise fail to state a claim. One is that the Sweeney property waived its right not to be bound by the restrictions by seeking approval. Just 3 quick points for that. One, this court has held that waiver is a defense. It's not a cause of action. It cannot be asserted as an offensive claim in a complaint. Second, restrictive covenants are forms of easements, and they can be created in several ways. I think those ways are express grant, reservation, implication, prescription, estoppel, and eminent domain. Waiver is not one of them. Cannot create a complaint by waiver. And third, this court rejected a very similar argument in a Hutton case, the Hutton v. Ingalls case, where a developer sought a Ingalls grocery store's permission to develop a certain out parcel that Ingalls claimed a right to control. Ingalls denied permission. Then the out parcel eventually argued, well, we don't need your permission. Eventually that gets up to the Court of Appeals. Ingalls argues whatever deficiencies there may have been in our document purporting to give us rights to control development, they waived that by seeking our approval. And this court said, we're not finding a waiver in that situation. Quote, those actions can be attributed to other provisions of the lease, continuing on, or understandably, the landlords may have sought to avoid approving any development that might upset their anchor tenant, whether or not the lease required them to do so. So I think their waiver contention lacks merit. And I want to touch briefly on their claim for implied negative reciprocal easement, because I think this is has the potential to be very instructive to the bar. As a real property practitioner, I hate implied negative reciprocal easements for the exact reason that the Supreme Court in Nebraska discussed, which is they're not of record, they muck up title to property. But more importantly, that doctrine arose in an era that no longer exists. That doctrine arose in an era where development of subdivisions was typically done where a developer would impose restrictions on a parcel-by-parcel basis, as opposed to filing a set of declarations all at once on an entire general plan area. The plaintiffs generally allege the elements of an implied restrictive covenant here, but we can still know that they fail to state a claim because the face of the complaint shows that there are express restrictions that do apply to the property, which is the declaration. And the restriction is we have an obligation to contribute to maintenance for the common areas on a pro-rata basis. And the restatement has a comment that says, look, the implied negative reciprocal easement doctrine doesn't apply or comes into play only when a developer does not follow the practice of recording a declaration of servitudes applicable to a general plan area. The Tennessee Supreme Court recently, in the Phillips v. Hatfield matter, discussed this rule. It didn't apply it, but it discussed, but it also approvingly cited a Nebraska case that I'll touch on briefly that applied the restatement rule of saying if there's an express restriction at issue that governs the rights and responsibilities and it doesn't encumber this property in a certain way, it can't be applied by way of an implied easement. In that Nebraska case, this may be the most comparable case I've ever dealt with as a practitioner. You could almost substitute some dates and names. But there, the plaintiffs bought some property next to a platted subdivision. It was originally owned by the subdivision's developer. They constructed a barn on the property, which gave rise to a dispute. It's the exact same here. Court held that the restrictions didn't expressly apply to their property. The court also rejected the applicability of enforcing those restrictions by way of an implied negative reciprocal easement as well. I mean, in the rule, I think it's very similar to the comparable context of where you cannot have an implied or quasi-contract exist where there's an express contract that governs the same subject matter. We cited a case that dismissed for failure to state a claim a quasi-contractual claim because the complaint acknowledged in that case that there was an express contract governing the same subject matter. That's the exact same facts as here. And for that reason, we know from the face of the complaint and the reference documents that the restriction controls, and it doesn't encumber our property in the way plaintiffs suggest, and for that reason, they have failed to state a claim for an implied negative reciprocal easement, and this court should affirm the trial court's dismissal of that and their other claims as well. Thank you.
Thank you, Your Honors. I do have a couple of points to raise in rebuttal. First, I'd like to acknowledge that the appellee does acknowledge that the declaration does in fact encumber the subject property, and I would refer, Your Honors, back to my previous comments about looking at the other sections, the other articles that do not specifically apply to any one set of property, that just gives, for example, the advisory committee plenary authority to approve new construction. So we would submit that all of those, the entire declaration does apply. Another issue is the something more that Your Honors discussed, that has been discussed in the case laws as well. Voting rights. Voting rights were provided in the transfer from the developer to the purchasers in the Hill deed. The purchasers were provided with rights to vote in the association. I would submit, Your Honors, that that is a declaration that the property is explicitly being permitted to participate in the association. I would also like to distinguish quickly the points raised by counsel about the cases cited. I'd like to reference Letzak and point out, I'd like to read briefly from Letzak that the developer in that case, it says, the warranty deed conveying undeveloped property to the trust did not expressly reference the declaration. Rather, the deed provided that the conveyance was subject to all conditions, easements, and all other matters of record in the Registrar's Office for Williamson County, Tennessee. Later in the court's holding, the court says, defendants assert, and we agree, that Spring Hill Partners could add more property to the terms of the declaration without expressly calling the document a supplemental declaration. Even so, the method used must comply with the quoted language. Here, Spring Hill Partners, the developer, simply failed to add the trust property to the terms of the declaration. The holding was that the developer didn't transfer the property. This is what was found also in the Winstead versus Byerly case. The court called that the deed transfers from the developer a comedy of errors. The court couldn't find a single document from the developer that was recorded that added the restrictions that bound any of those properties to the restrictions. And that's also the case in Massey versus Graff. The court found ambiguities in the deed transferred from the developer to the next purchaser in whether or not that property was bound to the declaration. Your Honors, I would submit that in this case, there's no ambiguity. The developer intended to transfer the property at issue to the subsequent buyers and bind that property to the declaration. The developer followed the process, and the entire declaration should apply to the property at issue. Thank you, Your Honors.
Thank you. Thank you, counsel. We appreciate your briefs, your oral argument. We'll review the record and attempt to prepare an opinion at the earliest